Today's speaker is Mr. Mukhit Yeleuov, who is a senior partner at the law firm in Kazakhstan, Kinstellar. Mukhit is one of the leading dispute resolution lawyers in Kazakhstan with international court and arbitration experience. He is a member of our court and IAC user committees, and he's been an active supporter and collaborator for our court and arbitration center in Kazakhstan for some time. We have 1 hour for today's webinar. Mukhit will give his presentation and he will then open the floor for questions. We ask you please to write down your questions in the Q&A section of the Zoom webinar program. It's located at the bottom of your screens, and Mukhit will answer your questions at the end of his presentation. So without further ado, I hand over to Mukhit. Thank you very much.
Thank you, Chris. It's a privilege. Let us kick off. Basically, let me first of all outline the presentation itself, the limitations, disclaimers. Almost all of us being lawyers, it's probably important to set this out straight, first of all. So we searched the paragraph database, one of the publicly available databases. The search was for the years from 2013 through 2019. We did a limited search for the 2020 for obvious reasons, because most of the cases are not up in the system yet. We've used some keywords, so whatever results show up today are obviously only preliminary. We'd have to do a much more thorough search sometime later to give you, a stronger opinion on many of the items here. Other thing to mention, as you all know, Kazakh courts are usually quite short in their analysis of the facts and the law. And sometimes it's not very clear. So you should take the text and conclusions with a grain of salt. The other thing that immediately strikes us, or that we could see immediately, was that courts are not uniform in their application of the relevant articles of the Civil Code, which is not surprising, but something for us to know. The other thing, as you well know, a few days ago on May the 6th, the Supreme Court issued a clarification, разъяснение, on some legal issues related to force majeure. I will not cover the clarification during this presentation for obvious reasons. You can read it on your own, or most of you can at least. But I will mention a few things that have not been covered by the Supreme Court clarification, which in my opinion is not sufficient, because there are a number of legal questions that are still open, still not clear, and therefore the law may not be as predictable as some of the previous practitioners have mentioned, or as they have mentioned, it's not as predictable as it should be. And obviously, the presentation is not legal advice. Before we delve into the actual numbers and the actual quotes from the judicial acts, let us quickly refresh our memory so that we're all on the same page. So the key article is obviously 359, including its paragraph 2 and 3. And most of us are usually tempted to jump right into section 2 for obvious reasons, because it's the more detailed one. But we often overlook paragraph 3, which actually, when you think of it, is much more important for obvious reasons. Based on section 2 establishes the priority of the contract over Article 359, section 2, and obviously establishes the priority of other legislation over Article 359, paragraph 2. And we will come to specific examples how this plays out in many of the cases. For instance, in the case of construction contracts or many contracts which have force majeure provisions in them. So just to brush up your memory, paragraph 3 allows a contract or the legislation to set grounds for liability and to set grounds for exemption from liability, which may be different from the ground for liability and exemption from liability, which is stated in section 2, right? And as you remember in section 2, if you fail to perform, you're liable. So if you do not perform at all, or if you perform improperly, you're held liable. So the creditor is not obligated to prove the guilt unless you, the debtor, can prove that the performance was impossible due to this insuperable force, right? So that is the general standard which applies by default, unless we can apply something else on the basis of paragraph 3 of the same article. Let us quickly jump into the something else, because I think it is critical. So if we look at 359, it allows us to set contractual grounds for liability, and obviously they can be different from the general standard which is if you fail, you're liable. The obvious grounds could be, for instance, you're liable only if you're guilty, or you're liable only for intentional breach of an obligation. So something just to keep in mind before we start trying to use 359.2 is just to double check whether your contract has somehow amended the ground for liability. Likewise, for the ground for exemption from liability, for obvious reasons, because if you have a contractual ground for exemption from liability, it usually overrides the statutory ground provided by Section 2 of Article 359. The reason why I say usual, because as you well know, you can basically provide for any exemption from liability with the exception of intentional breach, right? You cannot exclude intentional breach because it would violate imperative provisions of Kazakh law. So if your contract provides for any exemption from liability other than intentional breach, it obviously overrides 359.2, and the court would have to apply the contract. That is why I'm using the word usually. What is important, I think, for us to keep in mind, because we're tempted to assume that the statutory definition of insuperable force, непреодолимая сила, is identical to the contractual concept of force majeure. And it is not that simple. I have seen a number of contracts which, for instance, have been copied from English law contracts or from New York law contracts, or just generally more sophisticated contracts where the contractual definition of force majeure substantially differs from the statutory definition of insuperable force. And for the remainder of the seminar, I will use the words insuperable force when referring to the statutory ground, just for us to be on the same page. So before we start applying 359.2, we obviously have to double check whether there is a contractual clause on force majeure and whether it is in any way different from Section 2 of Article 359. Because if it is so, then 359, with all of its difficulties and inadequacies, may not be relevant at all. And that may resolve many of the questions that you may have from a practical standpoint. The other thing to keep in mind, and this is something that is essential, is that 359.2, as we've just mentioned, also establishes the priority of other legislation over 359.2. That is to say, if other provisions of the Civil Code provide for other grounds for exemption from liability, we have to apply them, not 359.2, right? And obviously, a similar provision, but a more general one, is contained in Article 379, which, as you know, basically says that with respect to obligations arising out of contracts or so-called contractual obligations, the general provisions on obligations apply if otherwise is not provided by provisions of Chapter 22, that is Articles 378 through 392, or by rules on different types of contracts, which would be the special parts of the Civil Code. Now, obviously, the reason why we mention this is because there's a number of such cases. And I have seen, unfortunately, a number of courts even make mistake by automatically applying 359.2 without double checking whether the special provisions of the Civil Code have somehow amended the general rule of Article 359. So if we now look at 359, start looking at 359, this is the approximate questionnaire or the test or the tests, the criteria one has to walk through to see whether and how one should apply this provision. So obviously the first question is whether it actually applies, whether there are any statutory provisions other than this article or any contractual provisions. Second, does the event constitute insuperable force? And I'll be using this concept henceforth in reference to Article 359.2. What is impossibility of proper performance? Because it's an abstract concept, as any abstraction requires interpretation. Fourth, is there a causal link between the event of insuperable force and the impossibility of proper performance? And this is an issue that Kazakh courts look at quite intensely. And I have seen a number of cases where courts state that there is no causal connection, that there is no direct cause and effect between the inseparable force and the impossibility of proper performance. And obviously, but not least important, did the debtor or obligor, whatever term you prefer, properly notify the creditor of the event of the possibility of performance due to event of force majeure, the event of insuperable force. So let us start applying this test, and we'll start with the simplest issue and with the most obvious issue, although it's not as simple once you delve in. It's the issue of notification. And now, obviously, 359.2, for ease of reference, does not itself contain an obligation to notify. So one can easily conclude that there is no statutory obligation to notify, therefore, even if you fail to notify, nothing really happens. Well, it's not really that simple, because if we're looking for an answer of Kazakh law as to whether or not there is a statutory obligation to notify, we have to look through the entire civil code, more or less, even outside of the civil code. And the answer is yes, there is a statutory obligation to notify. And let me make a few examples. With reference to construction contracts, Article 628 sets a fairly clearly worded provision or rule. The contractor shall immediately warn the client, right, if the contractor did not perform, if etc., due to circumstances beyond the control of the contractor which make it impossible to complete the work in time. Now, as you can see, the words here are quite similar to the words used in 359. Right, performance is impossible. It's impossible to complete the work in time. Obviously, the impossibility to complete the work in time is just one of the examples of the impossibility to properly perform an obligation, right? It's just a specific example of the same general concept. So in the case of a construction contract, the contractor has a duty to immediately notify or warn the client, right, once it finds out of such a circumstance. And if, and this is the provision of section 2 of Article 628, if the contract did not warn the client of the circumstance, then the contractor loses the right to refer to the circumstance to be released of liability. And obviously, if the contractor in a construction contract is trying to apply 359.2 by reference to an event of insuperable force, which made it impossible to complete the work in time, but failed to notify, there is a high chance that a judge would refuse to do that just because the contractor failed to notify. And this is obviously applicable not just to construction contracts, I'm just using it as an example, but it applies to all work contracts, which is a fairly broad section of contracts, right, as you well know, договора подряда. Because Article 629 is contained in the general provisions on work contracts, not in the specific provisions on construction contracts, and therefore applies to all work contracts. Moreover, as you will know, it may even apply, and most likely even applies, to contracts. I may have to double check, but the general conclusion would be, if you remember, with respect to contracts for performance of services, right? The provisions of civil code on work contracts apply to such contracts on provision of services, unless the specific provisions of the civil code on the contracts and provision of services explicitly provide otherwise. So one has to be fairly careful with any work contracts which do not even contain the obligation to notify. One has to be really careful because they may be, or there is a statutory obligation to notify, which has a devastating effect under Kazakh law. Just because of the failure to notify, you lose the right to refer to the circumstances that you have not notified of the client. And this is just one example from the special parts of the civil code. And obviously, before you decide whether or not to notify, you should double check the specific part of the civil code which may be applicable because of the nature of your contract. And there's just one example of many such examples. One example of court practice, and in this case, the court refers to Article 628.1.3 and says the contract must immediately notify the client if circumstances beyond the contractor's control are found that make it impossible to complete the work in time. Then the court refers to section 2 of the same article and concludes such notification was not sent, and therefore the respondent's arguments about force majeure the court considers untenable. It's just one of the many examples where the mere failure to notify basically did not allow the contractor to refer to force majeure to excuse itself. let's go further, obviously. The question is there something else we should keep in mind in deciding whether or not to notify? And the answer is yes. Not only the special part, but also the general part of the civil code contains an obligation to notify. It's not easy to find. It's somewhat hidden, right? It's in Article 349(1) of the civil code. As you may remember, and you can read the text, violation of an obligation shall mean its non-performance or improper performance, right? And I've highlighted, I've boldened the key words for the ease of reading. And in case of impossibility of proper performance of an obligation, the debtor shall notify the creditor of that without delay. Nезамедлительно. Now, obviously, you can translate the word nезамедлительно differently. Some may try to translate it as immediately. It's a matter for discussion. I'm not going to spend much time on it. But the conclusion is simple. Even if the specific provisions of the special parts of the civil code do not provide for a statutory obligation to notify with respect to a specific type of contract, you would still apply 349(1), which obviously applies to all contractual obligations unless explicitly provided otherwise by some clause of the special part, but which does impose a statutory obligation to notify. And I have found an interesting observation or an interesting fact that courts, even some courts, when assessing whether or not a party was required to notify, sometimes analyze the contract, may even analyze the special part or review the special part of the civil code, but do not pay attention to Article 349(1), which does provide for a statutory duty to notify. So this is something just to keep in mind. Now, obviously, the next question arises: what if the debtor did not notify or failed to notify properly? That is, in time, or etc. Sent to the wrong address, or whatever you can think of in terms of improper performance of an obligation, right? So logically, when you think of it, and I'll come to the court practice in a few minutes, logically, when you think of it, there are three possible consequences, right? One, and the reason why we have to speculate, in a sense, we have to hypothesize, is because, as you can see from the text of 349(1), it does not provide for the consequences of non-notification, right? It just ends on the word the debtor must notify, and that's basically it, right? It doesn't say what happens if one fails to notify. So we therefore have to interpret the consequences of not notifying or not properly notifying the other party. And logically, there would be three consequences. So one could even think of other, but I have not been able, at least to date. One could argue there are no legal consequences. With reference to the text of 359(2), one could say if there was an event of force majeure, which made it impossible to properly perform an obligation, then one has the right to be released even if one failed to notify, because 349(1) or 359(2) do not provide for specific punishment for failure to notify. Okay, that's one position. The other position for failing to comply with 349(1) would be to say that it deprives the debtor of its right to be released from liability. Again, on the basis that it failed the statutory duty to notify, right? Third conclusion, or third position, which to me seems a bit more sophisticated and probably has a bit more ground, would be to state that although it does not deprive the debtor of the right to be released from liability, but it leads the debtor's liability for the failure to notify. The idea would be simple, right? Because neither 349(1) nor 359(2) explicitly provide that one gets deprived of the right to be released from liability because of non-notification or because of lack of proper notification. Therefore, one cannot be deprived of the right, right? So this is the first part of the analysis. However, the argument would go on, since it's a statutory obligation, which does not state consequences for its breach, then one has to apply general consequences for breach of an obligation, right? And general consequences would be, compensation of losses, or termination of a contract if the obligation is considered to be substantial, for instance, etc. So the general consequences for breach of an obligation provided by Kazakh law. This argument seems to have more grounds in terms of civil legal doctrine, right? Because they should be consequences for the breach of an obligation, but they should not be as harsh as deprivation of the right to be released, because the law does not impose that as a punishment explicitly. And I would say I'm drawn to this interpretation of the civil code, but obviously there's nothing conclusive in the civil code, which would, at least not to date, not that I'm aware of, that would say that this is the only possible interpretation of the consequences of not complying with 349.1, and therefore, and I would leave the question mark open for the moment. Let us now look at the court practice, but let us also look at the court practice with reference to the failure to notify if the obligation to notify is contractual, and I'll explain why in a minute, and I'll come back to 349.1, which provides for the statutory obligation to notify. In terms of contractual obligations to notify, the courts are not consistent. There may be reasons for that, obviously, because as I've mentioned in the beginning, the courts are not detailed in describing the content of the contract. The courts are not detailed in describing the facts or the legal analysis. So this may be not completely fair to the courts. But still, if one reads the judicial acts as they're written, the court practice is not consistent. Some courts, they argue that if you failed your contractual duty to notify, you get deprived of your right to be released from liability. So they go as harsh as that. Some courts argue that even if you fail to notify the other party as required by the contract, so you fail to comply with your contractual obligation to notify, it does not deprive you of the right to be released from liability. Other courts, and that appears in general to me to be of the approaches that have been used by courts, the third one appears to be the more reasonable one. The courts basically make a more complicated analysis. I mean, they're not explicit about it, they're not detailed about it, they're even somewhat superficial about it. I'll take the courage even to use that word, but they apply a type of common sense bona fide criteria, of common sense criterion and bona fide criterion. And they basically try to somehow explain whether or not the lack of notification had a material effect. And I think the concept which they have behind is the following. Had the debtor notified the creditor, would the creditor have been able not to incur certain losses or certain additional losses which occurred because of the lack of notification, right? So that appears to be the analysis that, or at least a part of the analysis or the arguments used by the court. But again, the courts are not explicit, not detailed. The Supreme Court does not discuss this issue in the clarification issued on May 6th. So I think the question would be, and I'll show a few examples, and then I'll come to what I think should be, at least based on what I know so far, the application of the law and the contract in this case. But let us just pay attention to a few examples. And as you can see, all of these court cases are recent, right? 2018, 2019. In one of them, the court says, the court does not take into account the defendant's arguments on non-fulfillment due to force majeure circumstances because in accordance with the agreement, the party shall immediately notify on the occurrence of force majeure. The defendant did not send the notice on occurrence of force majeure, and therefore the court comes to the conclusion that the reference to the given circumstance is not justified. So in this case, obviously, the court applies the harsh sanction, right? It says, you failed to comply with your contractual duty to notify, you are deprived of the right to be released. So this is the harsh approach taken by one of the courts. Another example, a bit fresher, 2019, actually almost exactly a year ago from today. The court says violation by the supplier of the 3-day period for notification of insuperable force does not undermine the fact of such circumstances. So in this case, obviously, the factual pattern is also different, right? In the first case, at least as far as we can see, the debtor failed to notify completely, while in the second case, the debtor seems to have notified, but with a delay, right? Not in time, not within the period provided by the contract. In any case, in the second court case, the court says, well, even if you were late, still it does not undermine the fact of force majeure, and therefore, and then continues to make the analysis as to whether or not, in this case, force majeure applies, etc. Now, so in general, again, in conclusion, the courts seem to be taking different approach. Sometimes they take into account whether the non-notification or the improper notification had material effect. Sometimes they take into account whether there was no notification at all, or whether there was a notification but it was delayed. So the courts seem to be taking a more sophisticated approach, or trying to come up with their own interpretation of the law, because the law does not explicitly give them an answer when they look at it. So let us now try to come up with what we think should be the proper application of the law if one fails the contractual obligation to notify. So if one fails, if a contract provides the contractual obligation to notify and the debtor does not notify accordingly, right? I think that the answer should be on multiple levels. First, if the contract does provide for punishment for breach of the obligation to notify, and as you well know, many contracts provide for such a punishment, right? Many contracts explicitly state, if you fail to notify, you can no longer be exempt from liability, right? So if we look at the second part, what I think is correct, if the contract does explicitly say that if you fail to notify, you suffer the punishment in the form of being deprived of the right to be released from liability, then the contractual punishment should apply. And the logic for this is simple. What I think is taking place in this case is, as you remember, Article 259.3 allows parties to a contract to contractually modify the statutory ground for exclusion from liability, right? So if the statutory ground for exclusion from liability, which is in 259.2, is impossibility of proper performance due to insuperable force, then in such a contract, actually, when you think of it logically, one can argue that the parties have modified the ground for exemption. And the parties require two things. One, they require impossibility of performance due to the event of force majeure, or the event of insuperable force or force majeure, if there's a contractual definition of force majeure. And to be exempt, a party must notify. If the party fails to notify, the party does not get exempt. So if we interpret such contracts systematically, if we take into account 259.3 and 259.2, then I think we should reach the conclusion that if the contract provides for punishment in the form of deprivation of the right to be released from liability, then that what should happen. The party was well aware of that provision when signing the contract. The party has agreed to modify the contractual ground for release from liability, and therefore, based on 259.3, that's what should happen, right? So, and I think it's a reasonable approach. A more complicated question is, what happens if the contract does not provide for the consequences of the breach of the obligation to notify? It simply says the parties must notify, let's say, at this address within 10 days, but does not provide the consequences for the breach of the obligation to notify. My general conclusion here would be the consequences should be the same as the consequences for the breach of the obligation provided by 349 of the Civil Code. I don't see why there should be different consequences for violating the contractual obligation to notify and the statutory obligation to notify. And I think that in this case, the court should take a reasonable approach, which should be twofold. One, it should not deprive of the right to be released, because neither the contract nor the law provide for such a punishment, which is a harsh punishment. But if the contract, if the creditor suffered some additional losses as a result of non-notification or as a result of late notification or otherwise improper notification, then the debtor should compensate these additional losses that could have been avoided had the creditor been notified. And I think such an approach would actually, when you think of the civil code systematically, if you take the doctrine into account, I think such an interpretation would probably make sense conceptually. But again, this is all hypothetical discussion so far. This is my personal view. It may change with time for obvious reasons. I'm still reading, I'm still trying to understand these concepts of the civil code, how they will interplay with the contract. But just one thing to keep in mind, I think for now, for us, that the court practice is inconsistent. Therefore, obviously, for practicing lawyers, you can pick and choose whatever court practice you want to support your client's favor. Obviously, for academics, this is a good subject to think of. I'm not an academic, but I'm writing an article now in Russian on this specific issue, failure to notify of force majeure and its consequences. I cannot promise the deadline or anything specific, but I'm working on the article, but it's taking much longer than I expected for obvious reasons. But again, something just to keep in mind is, again and again, even the courts seem to completely ignore 349, completely ignore different consequences of non-notification if the contracts provide for consequences, etc., and a whole range of other issues related to notification. Now, let us move on because we may be running out of time. The second element is impossibility of proper performance. I will not elaborate on this one for two reasons. I think Mukhit has given an excellent presentation a few weeks ago where he explained that we have a very high standard under Kazakh law. It's the impossibility of proper performance. It's not difficulty, so it's not hardship, it's impossibility. From a practical standpoint, what it translates into is the following question. Did the debtor take all possible measures to avoid the failure of proper performance of its obligation? I mean, that's as high as the courts take it when they apply and interpret this very high standard. And just one example, again, a relatively fresh court decision, just 2 years old. The court looks at the contract and then basically asks the following question. Which measures were taken by the defendants to find alternative ways to perform the agreement? In this case, to deliver goods. Did the defendant take measures to deliver the goods by either air transport or by railroad? And even though it's not entirely apparent, but it looks like the goods could not have been delivered as agreed. But and the court is asking, did the defendant or the debtor in this case try to deliver the goods in any other way? And the defendant tried to argue that air transportation would have been much more expensive, several times higher, and even higher than the agreed contract price, and that the rail transportation would take even longer. But the court says, I don't care. It's your business risk. It's your entrepreneurial risk. You defended, you accepted the obligation, and you were obligated to take all measures to properly perform because you are a business entity, you're an entrepreneur. So in this case, and this is again an example of the standard that Mukhit eloquently described, impossibility of proper performance. It's a very high standard. I have not seen anything different, at least to date. So we should assume that this is the standard which the courts will be applying in the future as well, but you never know and time will show. The third issue, which is equally important, is this causal connection or link, or cause and effect link between the event of insuperable force and the impossibility of proper performance. And this is where Kazakh courts appear to be relatively sophisticated. They actually look at whether there was a direct cause and effect. They sometimes say that there is no link, there is no causal link between the insuperable force and impossibility of proper performance. And on the basis of that conclusion, they sometimes deny, obviously to satisfy the argument that one should be released. One thing just to reiterate, right? I've given the courts a compliment. I should have said some courts are sophisticated. Many courts do not go into details, but again, something to think of if you're working on your, let's say if you're the claimant, which is trying to hold your contractual party accountable, and you're trying to defend or fight off the force majeure claims. Something to think of is the causal link, because it's such a complicated concept, often very heavily factual, which creates a number of opportunities for a litigator, in my view. So let us look at one of the interesting court cases, right? And this was you can read the text that is in bold, and I'll do so too, but I'll give you some background just for your ease and convenience, because you may be watching the presentation on your cell phone and you're not able to read. So there was a contract on supply of waste metals, right? And obviously one of the parties, both were local parties as far as I know, and the buyer was intending to resell or to take the waste metal outside of Kazakhstan. And the seller just had waste metal on its yard and was trying to get rid of it. So the contract was in place when the parties were trying to perform the obligations. The authorities, the government, the state body, introduced a prohibition on export from Kazakhstan of waste and scrap metal, which made it impossible for the buyer to sell the metal, to take the metal out of Kazakhstan, right? But the court was quite sophisticated. The court said further sale of metal, of scrap metal outside of Kazakhstan was the purpose solely for the defendant. So for the buyer of the metal, the scrap metal. The court said the claimant's purpose was simply cleaning its territory from or off the waste metal by way of its sale. And the court goes to conclude that the buyer had the ability to remove metal scrap from the claimant's territory to its own territory or to some other third party's territory. So the court basically said the fact that the buyer was not able to take the metal out of Kazakhstan does not mean that the buyer was not able to perform its obligation. Because the buyer could have just taken the metal from the seller's yard and placed it somewhere else. And therefore, there was no direct causal link, and therefore, there was no event of force majeure in this case causing impossibility of performance. And we have now advised a few clients of ours on different force majeure matters, and something we always flag is if you're making a force majeure claim or claim based on 359, insuperable force claim, or if you're trying to defend yourself against such a claim, pay specific attention and do a factual analysis on the issue of the causal connection or the causal link, because it's often much more complicated and much more nuanced than it appears on the surface, right? Because obviously, when you think of, the pandemic, which has all brought us together, but at the same time remotely, not in the same room, we all try to think that pandemic itself is such an event of force majeure, such a gigantic event of force majeure. But when you think of it, right, even the introduction of the emergency situation regime in Kazakhstan did not by itself make it impossible for many parties to contractual obligations to comply with their obligations, because as you well know, different cities were brought under lockdown at different points in time. Some were earlier, Almaty and Astana, for instance. Some were much later, right? For instance, in East Kazakhstan Oblast, you still have less than 30 cases of COVID-19, and it was one of the latest probably in terms of the lockdown on individual locations. So if the contract boils down to specific discussions and arguments about impossibility of performance, you really have to go into minuscule details to actually check and double check and triple check if, in fact, let's say some government measure made it impossible to comply, and if there's direct causal connection between force majeure and impossibility of proper performance. Just another example, I wasn't sure where to place this, but I still wanted to show you this court case because I think it is interesting. So the court says the contract was concluded in April 2011. The earthquake and an explosion at the power plant, and obviously Japan, occurred in March 2011. So the contract was concluded roughly a month after the earthquake and the explosion at the nuclear plant. And the court says at the time of conclusion of the contract, these events were known to the respondent. And then the court goes on to conclude that the absence of the desired product on the market in conjunction with the above events in Japan do not constitute force majeure. And I think what the court is trying to say here, even though the court may not be as explicit, is that there may have been some impact of force majeure on the impossibility of performance. But you, the debtor, knew that there was that event of force majeure when you were undertaking that obligation. So you should have thought about whether it will not impact your ability to perform or make it impossible for you to perform. And in this case, the reason why it was impossible for you to perform because you did not think it through. You promised to do something that you couldn't do because of force majeure, even though you should have thought about this. So one of the reasons, obviously, for the inability to comply, the impossibility to comply with the obligation, the alleged impossibility, was that you did not think it through properly yourself. And had you thought it through, you would not have been in this situation. So this seems to be the logic of the court, even though, again, the court is not very explicit. And I think another case, again, not as fresh, and possibly because there weren't as many events of force majeure or events of insuperable force in Kazakhstan lately, which is a good thing. But as you remember the events in Zhanaozen, the riots and the police had to shoot, etc. So very bloody event. It was all over the news, international news, local news, etc. So one of the parties tried to claim force majeure, and the court basically said the following. The state of emergency was declared in the boundaries of the city of Zhanaozen, so only one city of the oblast, of the Mangostal Oblast. Entry to Aktau, another city in Mangostal Oblast, as well as to the other parts of the Mangostal Oblast, were not restricted. Therefore, the reference is untenable. So there was no connection between the event of force majeure and the impossibility of proper performance, or there is no applicable event of force majeure in this case. And I think this specific case will be quite relevant as we proceed, because there will be a number of contractual disputes which will boil down to the question as to when a party was physically prevented from exporting its goods or maybe moving its people, depending on the location, the type of goods, because as you know, for instance, there were quite early bans and limitations on export of certain types of goods. Then they were eased and then they were introduced again. So it will be very factually dense in terms of analyzing the impact of this particular criteria. I have 14 minutes to conclude, and I'll just use maybe 5 minutes if I can, because there's something really important, and then I can take the questions. When I have read the Supreme Court's clarification, I was surprised by the fact that the Supreme Court is not discussing 374.1 and is not discussing Article 361 of the Civil Code. This was a surprise, especially given the practice. Let me start with 361. I'll just spend a very few minutes on this, just for you to think over. 361 says the following: if in a bilateral contract, performance by one party becomes impossible, and again, the same concept, impossibility of performance or impossibility of proper performance, due to a circumstance for which none of the parties is responsible, then none of the parties shall have right to demand performance of the contract, right? And again, there may be exceptions. It says a legislative act or a contract may provide otherwise, but if they do not provide otherwise, then no party will have the right to demand performance of the contract. And it sets a different consequence for the non-performance. It says, but in this case, the parties have the right to demand the return of all of that that was performed without receiving corresponding contra-performance, right? So in this case, if let's say one party did something to the other party failed to perform because it was impossible to perform, and there was a disbalance. One party received more than the other party. Then this article basically sets the right for the parties to get even through some form of compensation. Now, to be honest, I'm still digesting this article. I'm struggling, for instance, to answer the question as to why 361 is in the general provisions on obligations, for instance, not in the general provisions on contracts, because as is obvious from the text, it applies only to contractual obligations and does not apply to non-contractual obligations, and therefore logically should be in a completely different section of the Civil Code. But that's more of an academic question. The more practical question is why the Supreme Court has not given any answer on how they should be applied. And the obvious question is, how do courts apply this article? Now, we had to run a very quick search in this article, so the results are not conclusive, but we have found at least 13 judicial acts in which the courts refused to satisfy a claim to force the other party to comply with its contractual obligation, or in Russian, with reference to Article 361. And we have found 9 cases where the courts do mention 361, but refuse to apply it, or still force the debtor to comply with its contractual obligation. One other thing to mention, I'll wrap it up, maybe we can take this in the Q&A session, is the relationship between 374.1 on the one hand, which, as you may remember, provides that impossibility to perform an obligation terminates an obligation. Yeah? Невозможность исполнения обязательств прекращает обязательства. And how does this article work in conjunction with 2 specific articles applicable to contracts, which is 404.2.1 and 403.1, which in short provide that impossibility of performance is one of the grounds for unilateral termination of the contract, or rescission of the contract, and only rescission of the contract then terminates the contractual obligation. Now, I think in the case of 374.1 versus these 2 articles of the Civil Code, my general impression now, or my conclusion now, would be that 404 and 403 prevail over 374.1 because they provide for specific rules on contractual obligations and on what happens if it's impossible to perform the contractual obligations. And therefore, as specific rules, they prevail over 374.1 as specific rules. And you can rely on this general doctrinal concept of prevalence of specific rules over particular of general rules, etc. But to wrap it up, the big question as to what happens with the actual obligation, not with the liability, not with the losses, not with contractual penalty, but with the actual obligation in the case of force majeure is still open. Obviously, we should read the Supreme Court's clarification. The Supreme Court appears to conclude that the obligation continues to survive, but the non-performing party has a right to demand modification of the obligation, or изменение условий договора. But to be honest, I do not find that conclusion by the Supreme Court very convincing. This may be a bit too audacious, but I didn't see the analysis, I didn't see references, but again, that's the position of the Supreme Court, who am I to argue? But I think if the matter goes on, for instance, goes to international arbitration or commercial litigation in the High Court or something else, Articles 361, etc., will come back, and parties will try to rely on these articles, even though they were not mentioned in the clarification by the Supreme Court to argue that if it's impossible to perform, the other party does not have the right to demand performance of the contract.